Welcome back to the Fleeting Conversations podcast. I'm your host, Matthew Leffler, the Armchair Attorney. Today, we're talking about something big, really big. Nuclear verdicts, thermonuclear verdicts. Oh, there's a lot to catch up on. A lot of things to answer, a lot of questions to dive into. Before we get to do that, though, as always, I want to say thank you for joining us, for tuning in, whether you're watching this on Facebook or LinkedIn or YouTube or X, all the places that we go, or the podcast we put together after the fact, where we take the audio, toss that into Apple Podcasts and Spotify. This is Fleeting Conversations. This is a deep dive into things that are interesting in the supply chain or the law. And my hope is to educate you and entertain you as you navigate these very complicated things. As always, thank you to my friends over at DAT, Dial a Truck. Since 1978, they've been helping motor carriers find profitable loads and helping brokers do the business of brokering freight. DAT helps move America, and I'm happy to have DAT support in this podcast we've been doing now for a little bit. Normally, we bring on a guest. We talk about whatever topic they want to talk about and interview them. Today, no guest, just me, just old Armchair Attorney. That's right, just me today. A lot of stuff to catch up on. Before we can dive deep into these nuclear verdicts and all that surrounds them, couple of housekeeping matters. I am excited. I hope you are too. The Journal of Commerce Inland Distribution Conference is happening coming up September 30th. It's a couple weeks away. I'm very grateful because I have finished my presentation. Oh, if you're attending Inland 24, hashtag Inland 24, please check out my session on everybody's favorite post-employment restrictive covenant, perks as I call them, on non-competition agreements. Oh, there's a lot to catch up on. FTC, Chevron deference, all of the things. So please check out that. There'll be some links to the Inland Conference in the show notes, and check them out. If you're attending, please reach out and let me know. And I'll be joining DAT for DATCon. You know, DATCon, DAT hat. I'll be at DAT, the DATCon, in Kansas City, Missouri in about a month from now, end of October-ish. I'll be talking about probably this topic, not nuclear verdicts, but a whole bunch of other things. And then right after, like the same week, I'll be traveling to Dallas, Texas for the Broker Carrier Summit, where I'll be on a couple of panels as well as doing an Ask Me Anything. So if you have questions you want to ask me live and in person, you'll find out that I am not actually just a virtual artificial intelligence that is put here to dissuade you of all sorts of different things. No, I am in fact a real human being. And I'll be there to talk about some of the great issues facing our supply chain. And of course, I'll be at F3, the Future of Freight Festival. I'll be getting to do, and I cannot believe I get to say this, a fireside chat with Craig Fuller. I am very excited for that. So if you're going to F3, if you're going to Broker Carrier Summit, if you're going to DATCon, and if you're going to Inland Distribution Conference, please find me. I'd love to talk to you. I'd love to learn more about what you do and hopefully offer some advice or helpful tips and tricks as you navigate this wacky world of supply chain. We got some comments coming in. I love to see John Radvansky. Great to see you, Cynthia. I usually don't bring up the comments. And of course, Michael Fitzgerald. I love Michael Fitzgerald. You should follow Michael Fitzgerald. Very smart guy. Look, I have a lot to catch you up on. If you haven't been paying attention, this is going to be really, really interesting. This is law. This is the law happening right now in your supply chain that actually will impact everything going forward. And I cannot emphasize this enough. The days of the nuclear verdicts are changing. The frequency and the liability facing motor carriers, shippers, brokers, and really anybody who's a stakeholder in the supply chain is only increasing. And so the hope for today is to break down 3 cases, really emphasizing 2 cases, and help you understand what they mean for our industry, why they happen, what the outcome is going to look like, and how that's going to impact you as we rock and roll. Okay. Music's done. We're going to start off with the one in the news right this second. That's the Wabash case that just came out literally about a week and some change ago. This has to do with a trailer that was rear-ended by another vehicle. The people in the vehicle passed away, and we had a crazy litigation that is now in the news all across this country, probably going global. It's massive. It is a $462 million verdict. Hold on a second. I gotta get something to drink. That's a mouthful. Hold on. $462 million? How in the world is that possible? How in the world is that possible? Let me explain. This case starts up 2004, 20 years ago, when that trailer was manufactured. When that trailer was manufactured, it had a rear impact guard, a rig. Some people call them, I call them ICC bumpers, but it's a metal tube with supports that connects to the rear door frame of a trailer. These devices, these rigs, these rear impact guards are in place to do one thing and one thing only. Other things you can do, but the primary thing is to prevent underrides. Now, that is a very disinfected term. Many people don't talk about the way that I'm going to talk about it today. If you're squeamish, if you don't like to hear things about like blood and guts and viscera, this is probably not the podcast to listen to, not the thing to watch. It is gruesome, but it's important that you understand what it actually is. An underride happens when a vehicle collides with a trailer and it goes under the trailer, and that rear door frame, the back of that trailer, comes to meet you. When you have one of these rear impact guards not in place, or they fail or are defective, you have an underride situation. It is essentially decapitation. That's what happens. The engine block of the car goes underneath the trailer, and the rear part of that trailer comes and meets you, and it's lights out. It is you're dead. That's what happens when you have an underride. Underride is essentially a descriptive term to say we have people that have just been decapitated. There's rear impact guards. There's side impact we have to talk about. We'll get to that one later in this broadcast. But the rear impact guard, the law of the land, the federal government set a long time ago to allow for a underride protection if a vehicle is traveling 30 miles an hour or slower. So you're going 30 miles an hour, you hit the back of that trailer, you're not supposed to go underneath it and have an underride. You're supposed to stop with that ICC bumper, that rear impact guard. It was recently changed. The number went from 30 miles an hour to 35 miles an hour. So newer trailers have to accommodate the 35 mile an hour speed. That is what is required by law today. There was not a requirement to retrofit existing trailers. They were just left to do their own devices, but newer models had to be made to support prevention of an underride at 35 miles an hour. And that's what's happened. That's what they do. That's what the manufacturers are, or that's the legal standard the manufacturers are held to, is to prevent underride at 35 miles per hour at a rear impact. Well, this case is really strange. This case is really strange. The accident takes place in 2019, 14 years or so after the trailer itself was manufactured. The person who was operating the truck and trailer was a company called GDS Express. They were at a standstill in a road in Missouri around St. Louis. And another vehicle came careening at them at 55 miles an hour. It smashed into the rear impact guard. The rear impact guard disintegrated. It got smashed up, and that vehicle went underneath the trailer. Both the driver and the passenger died. They both died. There's some facts we're going to talk about that the jury in that case did not get to know. We'll talk about why they didn't get to know this. But two facts that you're going to see in every single news report is going to be, one, that the driver had a blood alcohol content above the legal limit. Yeah, he was probably inebriated. And two, neither the driver nor the passenger had seatbelts. They didn't have seatbelts. So 55 miles an hour, well over the established speed that the federal government mandates for rear impact guards, smashing to the back of that trailer, dead on impact. What happens next? Well, everybody gets sued. That's what happens. Everyone gets sued. And so they sue the motor carrier, GDS Express. They ended up going bankrupt around a couple months after this thing took place. So once this litigation was readily apparent, they knew they were toast. And then the litigation against Wabash. Now, the litigation against Wabash is not about negligence. And I have to emphasize this because this is probably one of the biggest things that's confusing people is why is this strict liability and not negligence? So negligence is a tort. Strict liability is a tort. These are civil actions that are brought against somebody who's caused allegedly some sort of harm. And there's different ways you evaluate them. Negligence, you all probably know how it works. It's a duty to a duty of care. Don't speed around. There is an element of a breach of the duty. You did something wrong. There's causation. So you had a duty, you had made a breach. That breach caused something to happen, and the thing that it caused was damages. So duty, breach, causation, damages. When you're talking about negligence, the act of another person, like what does someone else do, matters an awful lot. Like we really do care if you were contributorily negligent. That's an affirmative defense. We can say, look, this person did something dangerous. They were careless too, so they should also be at fault. And that's what negligence is all about. But this case, the Wabash case, is not about negligence. That's not the standard. That's not the thing we're looking at. What we're looking at is something called strict liability, product liability. And in product liability, we don't really care about the actions of the other person. As long as the product was used in an anticipated way, that's all we're asking. So in this Wabash case, what took place was that the rear impact guard was challenged as being defective. It was challenged and said that rear impact guard, when it was made, it was unsafe. Now, I know what you're thinking. You're thinking, well, Matt, didn't Wabash do what the federal government told them to do? Didn't the manufacturer follow the established law of the land in terms of what is compliant for manufacturing a trailer? Of course they did. Of course they did. But that's not what we're talking about. The plaintiff has argued successfully in this case that Wabash knew or should have known that the rear impact guard should support a much higher rate of speed, not 30 miles an hour, not 35 miles an hour, 40 miles and above, much, much faster. And the question about the failure, the damages, this is a question about the anticipated use of a rear impact guard. Ladies and gentlemen, a rear impact guard, that is designed to be smashed. It is designed to be collided with. Now, my freight friends who were watching or listening, yes, the ICC bumper, the rear impact guard, can often be used with dock locks. So you back a trailer into a dock, it clamps onto the bumper, and then you can't move the trailer. You can pull it really hard and maybe break it, but that's an ancillary benefit of a rear impact guard. They're not necessarily designed or intended all the time to be used in dock locks, but that is a use case. No, this is about a protective barrier to stop you from crashing underneath a trailer and being decapitated. That's what the rear impact guard is designed to do. But oh my goodness. You're talking about a trailer made in 2004 that met the safety standards of the time. And then it gets put into a position where the manufacturer is sued for making it defective at the time of manufacturing. Let's talk about the numbers. A lot of people have come to me and said, Matt, those numbers seem bananas. Wabash is making a few billion, they're a couple $1 billion a year company, $2-3 billion a year in revenue. How in the world do they get hit for $462 million? That's a lot of money. Here's how it works. The compensatory damages in this case, which is the payment back, like when you die, we can't bring you back to life as a lawyer. That's not our power. What we can do is we can get you money. So the money, how much is your life worth? That's a question we don't think about a lot. I mean, lawyers think about it every single day. That's what we're paid to think about. But for most people, we don't think about how valuable a human life is. In this case, both the driver and the passenger received $6 million in compensatory damages. That means that each life was worth $6 million. Now, that still leaves $450 million. Where is that? What is that? Those are what we call punitive damages. punishment damages. This is the damages that are given when we think the defendant was so egregious, so wrong, that they should have to pay more than just the making the other side whole with money. They should pay punishment. The plaintiffs recover this. The lawyer gets their fees. The people who were injured get their part of the punitive damages. And in this case, how they got the number is fascinating. They made the argument in front of the jury that Wabash knew that these rear impact guards were insufficient. They posited that you could make a rear impact guard that would suffice in this circumstance for $313 per trailer. I don't know how they got that number, but that's the number that they went with. So they did some fuzzy math and said, because Wabash didn't invest the $313 on every trailer, that meant that they saved $15 million a year. And because Wabash saved $15 million a year, that meant that for a period of 30 years, Wabash made $450 million in additional profit. That is how we get to this number of $450 million. Now, I know what you're thinking. You're thinking, Matt, we really do need tort reform. Clearly, this is run amok. Interestingly enough, Missouri has tort reform, or at least a version of tort reform. They have a provision in their statute that says punitive damages can be one of two things. They can be $500,000, one way to go, or they can be 5 times the compensatory damages, meaning that the compensatory damages gets tied together with the punitive damages. So no matter what happens, that $450 million of punitive damages will be changed. It will not exceed $60 million. So there is a path. We know this path exists that Wabash will get that number reduced. Just for your own kind of legal edification, we don't usually tell the jurors we're going to change their verdict. We don't come in and say, hey, just so you know, no matter what you say and do, we're going to override you based on this statute, because you might be surprised, but jurors, if you tell them the limit is this, they go for the limit. They go, oh, it's 5 times compensatory. Well, we'll just give them 5 times compensatory. That's not why we want them to know. So we let the jurors figure out what the jurors do. You, in your jury box, we're not going to interfere. You make your decision. But just understand, we're going to change it if we need to. This is an interesting segue, I want to say, which I hesitate because I think it's a little bit more nuanced than others might like to approach, but this is not the lawyer's fault. I know we all have very strong opinions of lawyers. Me being a lawyer myself, I understand. I'm probably the last person you want to see on a given day, but we are solving a demand that exists. When something happens, you need somebody to help you. And lawyers get paid traditionally one of 2 ways. The most common way that we get paid is an hourly fee. You pay for my attention. You pay for my time. You pay for my consideration. And that is a very easy thing to do. I've spent 3 hours on this. I bill you for 3 hours. I've spent 100 hours on this. I bill you for 100 hours. The reality is most people can't afford a lawyer. Businesses can, sure, but most individuals can't afford somebody like a lawyer all the time. And especially in torts, personal injury, wrongful death, slip and fall, traffic accidents, underwrite accidents, you can't afford a lawyer because you don't have the kind of money. So what we attorneys do is a thing called a contingent fee. Contingent fees are agreements between me and you that I don't get paid anything unless I win. Now, we have to define what win means. Usually win means I get some amount of money that's awarded or offered by the defendant, and then I get a piece of that. But that means that if a lawyer litigates a case like this Wabash case and they lose, they get paid nothing. The cost to file, the cost for the experts, the cost for printing, the client has to pay that. The client must ultimately pay the cost of litigation. But the lawyer makes nothing. This is like the ultimate sales business where you're pure commission. That's contingent fee arrangements. typically, in most personal injury cases, and it changes based on the cases, but it's about one third of the total amount recovered goes to the lawyer. That's why lawyers are paid the way they are. That's why they have their billboards or they do their advertisements, because they want to get more contingent work. It's very remunerative. But you could also know that if they aren't successful, they aren't getting paid anything. The real issue, and it might just be an exercise in marketing or legal tort reform, it's jurors. Jurors have these ideas in their heads about how much a human life is worth, how awful a company is in their behavior. And it's always the roll of the dice when you ask a jury to come back with a verdict over how much something is worth. That is why we're seeing what I fear to talk about, which I'm now calling thermonuclear verdicts, verdicts that are over $100 million. Now, I'll take a brief pause here to define some terms. I think it's helpful to define terms as we talk. Nuclear verdicts is not a legal term. It was not invented by lawyers. We don't come around and say, "Oh, that verdict the other day, that was definitely a nuclear verdict." No, that's an invented term for non-lawyers. But the colloquial definition, the general understanding of a nuclear verdict, is when there's over $10 million of liability. When you have to pay over $10 million, we call that a nuclear verdict. And you see it in the news all the time. But nuclear verdicts, being a function of the total dollar amount, again, it's not a legal distinction. That's just a thing made up by non-lawyers to describe an activity happening. Do you have any idea how expensive medical care is in this country? Probably. If you go to the hospital and you're hospitalized for catastrophic injuries for 2 or 3 weeks, it's hundreds of thousands of dollars, maybe millions of dollars when it comes to the pain and suffering, future medical care, physical therapy. If you have to get lung transplants or organ transplants, that's another category of really expensive things. So it's not a function, I think, of the lawyers driving this, but they're part and parcel to the problem. So back to Wabash. A week ago, they are hit with $462 million. And in that context, they are determined by that jury that those ICC bumpers are defective. They do not comply with what should be the normal thing. What do you do if you're a motor carrier? There are 5 million trailers across the United States, and every single one of them, by the definition of this case, they are defective. They are defective. That should make everybody concerned. The idea that every single trailer on the highway today should be built or retrofitted in such a way to prevent an underride of a vehicle traveling over 40 miles an hour is bananas. The amount of work to retrofit a trailer to accommodate a bumper that could handle that, you are talking thousands of dollars in labor and materials. You are likely talking hundreds, if not thousands of pounds of additional weight, now presumably maybe being required in order to meet this new standard. This is not standard. This is not accurate. This award in Missouri is an aberration. The industry will absolutely circle up and try very vigorously to have this verdict overturned. If the U.S. Chamber of Commerce and the American Trucking Associations are not already involved, and I suspect they probably are, they're going to fight this tooth and nail. When we had an updated version of the rear impact guard laws that required, additional 5 miles an hour of additional protection, we didn't retrofit the entire fleet. We didn't do it. It would be too cost prohibitive. This is not the market to support thousands of dollars per trailer in order to make them compliant with some new innovation. But lawyers are crafty. Lawyers are some of the most creative problem solvers you will ever meet. If you want to really understand true innovation, step into the realm of a very successful plaintiff attorney. There's no doubt, based on this litigation, that every single rear end collision is going to have some aspect of this ICC bumper, this rear impact guard litigation. It is going to be going after every manufacturer. They will go after every motor carrier. And if you're a broker running a bunch of trailers, you may be tagged too. This is something that we do not know the ultimate outcome for, but we do know one thing. Insurance rates will absolutely go up as they try to mitigate and understand and process a risk that was never intended. Again, the federal government said these rear impact guards must support 35 miles an hour and under. That's the speed that we must prevent underrides. Not 40, not 45, not 50, not 55, 35. If that's insufficient, I am very concerned about what the future means for transportation. Those trailers that are coming off those lines are 35, 40,000 bucks a pop. Maybe they're going to come down the line at 55 or 65, like the COVID era, like the expensive equipment. So this case is one that we have to keep in mind. Now, I do think no matter what, the punitive damages go down substantially. I also think I'm going to predict, and I've been fairly accurate with my predictions, on appeal, this will be either reduced or dismissed entirely. There's just no way this liability can sustain itself. For people who I've mentioned this when I posted this on Reddit and other places, I've gotten some questions about just rear impacts generally. Let me just say this. In negligence cases, again, not strict liability, in negligence cases, if you smash into the back of someone's vehicle, trailer or otherwise, you're at fault. Like, we assume as a society and as the legal profession and all this, we assume you're at fault. It's a rebuttable presumption, which means to say you can offer evidence to overcome the burden. Like, oh, I was following behind and they slammed on their brakes and I could not stop and I hit them. Therefore, I'm not at fault. They're at fault. But again, this is not that case. This is a case about strict liability. And if the standard of strict liability for rear impact guards is that they must support a much higher rate of speed, we need to be very, very concerned because that is impossible. There is no rear impact guard solution that I'm aware of that could prevent an underride at a vehicle traveling 55 miles an hour. Maybe there's some really special ones you can get, but not that I'm aware of. And if you are wondering what happens next for the millions of trailers that are on the highway, I don't know. I don't know what you do next because this shouldn't happen. Speaking of things that shouldn't happen, we're going to get to case number 2. Case number 2 is Werner Enterprises. You've probably heard about this case. It is set for an oral argument in the Texas Supreme Court in December, I think December 3rd. Let me tell you the facts because if you haven't followed the case, you're going to be upset. And I'm just going to tell you that now. You're not going to like this case. If you have followed the facts, then this will be this kind of a helpful update. Story goes like this. Truck operated by Werner Enterprises is driving down the highway in Texas. It is a little snowy, a little slick. The driver for Werner is traveling under the posted speed limit. The vehicle is well maintained. There's no defects as far as we know on the truck or the trailer. And the driver is fully licensed, accredited, all of the things they need to be a commercial vehicle operator. In the opposite side of the highway is another vehicle. And that vehicle is a pickup truck. And it's driving too fast for conditions. That pickup truck, loses control, crosses the median, I think 10-yard median, something like that. And it collides head on with the truck operated by Werner. In an instant, one child is dead and another one is critically injured. And we asked ourselves the question, who is at fault? Who's responsible when another vehicle in the opposite side of the highway loses control, crosses the center line, and smashes into you? Next time you're driving on the highway and you're just, kind of thinking about the world, you might imagine someone crossing the center line and how quickly that impact happens, how much time you have to react. Um, not a lot, not a lot. Well, this case eventually goes to trial. And at trial, it's argued, among a lot of things, that in fact, it's not the pickup truck driver's fault, though they're partially at fault. It's actually not even the truck driver's fault. Again, they're partially at fault. The jury comes back with something very surprising. In that case, they said the pickup driver, I believe, was 16% at fault. 16%. The truck driver was 14% at fault. Get you 30%. What about that other 70%? Werner. Werner is found 70% at fault. Now, there's a lot of interesting caveats to the Werner being 70% at fault. There's facts that aren't super helpful. The driver was fairly new. The driver had a trainer, but the trainer kind of functioned as a team driver. And so the trainer was asleep in the back. It was a just-in-time load. So there was a desire and need to make sure the delivery happened on time. The truck driver didn't have a lot of training on snow and ice, but the truck driver was going under the posted speed limit. And the truck driver was going at a rate that they had control over the vehicle. They didn't really do anything wrong. If nothing else happened, that truck would have been fine. That verdict was over $100 million. $100 million. Now, there's a thing we should talk about briefly called joint and several liability. It's a legal tool that says if you're partially responsible or majority responsible, you can be on the hook for the whole amount. You're jointly and severally liable for the entire amount. But let me ask you this question, because I'm curious. Imagine you're driving home from work and you're going the speed limit, and someone loses control and smashes into you. Do you expect to be held responsible for that? Do you think that you should be responsible for the negligence of another? I don't think so. I don't think that's the right answer, but that case was appealed. This Werner case in Texas was appealed to the appellate court. And they went to the appellate court and they asked the appellate court, please reverse. This doesn't make any sense. And the appellate court didn't do that. And when you have a verdict and you postpone the payment, we have a thing called post-judgment interest. It's the compounding of interest until the eventual payments are made. And now that verdict is over $130 million. That is more, substantially more than it was initially. And now we wait for the Texas Supreme Court to weigh in and to tell us, will that company be responsible for this absolutely crazy situation? This is the landscape that we are facing, ladies and gentlemen. The reality of what happened to Werner was that they were told, if you had just been going slower, if you had just gone 10 or 20 miles an hour slower, that collision never would have happened. Of course it wouldn't have happened. They were going faster. It might not have happened. We don't play in the world of the time variance authority. It is not a question of if you did this one thing, everything else would have been perfect. This is not the butterfly effect. This is a motor vehicle operated by a passenger car, just driving on the highway, who was going too fast, who then slipped out, who then crossed the center line, came into another lane of traffic, and collided head on with a motor carrier. What does that mean for you? If you're a motor carrier, that means that even if you do everything right, if you follow every traffic law, that doesn't mean you're safe. It doesn't mean you get to walk away. What it means is that you might be on the hook. Now, insurance companies have two duties. I love talking about this with my insurance company friends. There's the duty to defend, which is the lawyer is obligated to defend you in court. We are going to do that for you. And then the duty to indemnify. We will then step into the place of you and pay the money up to the policy limits. The duty to defend is broader, generally speaking, than the duty to indemnify. Indemnification is about the amount of money the policy is for, and then they give it up. This is the part of this discussion that I think gets the most controversial. Do I think Wabash got a raw deal? Yeah, I think that case should be thrown out. It should be reversed. I have no desire, no belief that ultimately that Wabash should be, liable for anything, let alone $462 million. I also don't think Werner has any legal responsibility in that context because that is bananas. But we as an industry have to come to terms with something. And if you're new to this business, it might surprise you, but if you're not new, then you know this. The average out of service rate for commercial vehicles in the United States, on average, 21.6%. 21.6%. That means for every 5 vehicles on the highway right now, one of them is unsafe at any speed. Maybe it's a light that's out. Maybe it's a tire that's a little worn down. Maybe it's lug nuts that are loose. Maybe it's airlines that are rubbing together. Who knows what the defect is? But by and large, those defects are brakes, lights, and tires. Those are the 3 biggest obstacles in vehicle maintenance. So you have this idea of 1 in 5 commercial vehicles being unsafe at any speed. And you also have this question about insurance. And I love insurance. I love talking about insurance. The minimum insurance required for a motor carrier in the United States, generally speaking, is $750,000. $750,000. That number was established in 1980 with the Motor Carrier Act of 1980. It was the one that deregulated the industry, but it was also the act that set up what the minimum insurance amounts are. That number is not tied to inflation. If it was, it'd be closer to probably, let's say $5 million, $4 million. Every time the industry has tried to adjust to have it be higher, to have a higher rate of insurance. It is fought viciously. And so we've never seen that minimum rate increase. So what do you do with this knowledge? It now appears that there are trailers on the road that may not be safe under any circumstance, under any framework, because of this case out of Missouri. You have a case in Texas saying that if you are doing everything right, but someone else is crazy careless and they hit you, you're at fault. But you also know that the industry has a problem with underinsurance and a problem with maintenance. This is what's making the lawyers look at us. They're looking at us. Now, I am a lawyer. I identify as an attorney. I pay my fees. I have my license. All the paperwork is on the wall. But more than that, I'm one of you. My grandpa ran a trucking company, had 6 pieces of power. My father's first job out of college was working in maintenance for roadway. I understand, at least to an extent, what this business is all about. And today, the plaintiff attorneys are following a thing they call the reptile theory. I'm sure you've heard of this. I want to discuss it briefly. We're getting all the legal stuff in today. The reptile theory is generally understood as a way that lawyers target jurors to think about, what if this was you? What if this was your daughter or your son? What if it was your wife and they came and they did this? It's not about the driver of the truck having a bad day. They're a victim too. The reality is this industry is the problem. This company is the problem. Put yourself in the shoes of the person that was injured, and now you know what the reptile theory is. Ladies and gentlemen, it's not new. That's what we always do in litigation. The whole point of litigation, to get in front of that jury, is to tell them a story, to tell them the story of why we're here today. Why are we here today? We're here because of this company doing something so terrible. And so because it's an exercise in storytelling, what is the story we tell about our industry? What is that story? If you look at the headlines, it's concerning. Driver churn, crazy levels, the freight recession that's been going on for a few years now, longer than the previous freight recession in 2008, deeper. What do you tell them? We know motor carriers right now are moving freight at rates beneath their operating cost. That's a pretty concerning thing to think about. 1 in 5 are not safe. We're not insured properly. This is why the plaintiff attorneys are targeting other organizations, other entities. When the Wabash case happened, they sued GDS Express. They sued them under the theory of negligence. They said the ICC bumper wasn't maintained. It was rusted through. They didn't maintain it. But GDS is bankrupt. GDS had insurance. They probably tendered the policy, give the entire policy limits, and said, we're done. This is over. It's the most liability we're going to pay. Who else has money? If you're a broker, don't think that you've escaped. I talk about the broker liability question all the time. This idea of F4A preemption. Yes, broker, you do price, route, and service. But there's this thing called the safety exception. In some federal jurisdictions, you can also be held liable for the carelessness of the motor carrier. And we just established that the motor carrier can be responsible even if they do everything right. Even if you do everything right, you can still be on the hook for $100 million. This is not the nuclear verdicts we heard about 5 years ago, 10 years ago. These are different. This is new. This is thermonuclear verdicts. Just a couple of days ago, we saw Daimler, a truck manufacturer, get hit for $160 million. $160 million. That case is one we're going to end our conversation about today, and I'll take questions. There's been a lot of comments, and I appreciate that. The Daimler case, as I understand it, is like so many other cases. Another vehicle, not the commercial driver, another person, the vehicle, pickup truck again, something like that, loses control, crosses a center line, and forces a professional driver to make a split-second decision. And the driver in this case, the one in this Daimler case, made the split-second decision to turn, to veer, rolled the cab. In the process of rolling the cab failed. And it came down when it fell, and it hit the driver on the head, broke his neck, made him a quadriplegic. And the question is, who's at fault? You can't bring back the dead. Can't do that. You can't reattach functionality to the rest of your body. Not yet. Maybe someday. Maybe you should get a doctor on here. Tell me what's possible. No, this driver's paralyzed. They sued the other motorist. They sued the other company, of course, and they settled that. But it doesn't scratch the full itch. There's still a lot to be discussed about future medical care, pain and suffering, physical therapy, all the challenges, all those dreams turned off. And what the driver for that trucking company did was they sued the manufacturer. They said to the manufacturer, there was technology that you had as an option that would have prevented my seat from moving the way that it did, and it wouldn't have caused my head to hit the top and break my neck and paralyze me. That's what they did. That's what that case was. And Daimler is hit for $160 million for a strict liability claim. You should know the risk that this happens. The anticipated risk of rollover occurred, and therefore you're responsible for damages. Safety is something that is so hard to really pin down. When are you safe enough? If I could be dictator for a day and I was going to make the laws that would be the best for everybody and everyone's going to have a great time and live the longest, I'd mandate everyone wear a helmet. I would. It would probably be, it's definitely illegal, but you could conceivably make everyone wear a head protection, and that would probably prevent a lot of deaths. But we have this continuum of what exercise of power we should have over some and what we shouldn't do in terms of safety. So you have three cases. Wabash rear-ended their trailer that was built 20 years ago, and they were found $462 million responsible under strict liability. Then you have Werner, who is driving a truck in their lane, never losing control, well-maintained, gets hit by another vehicle who crosses the center line, smashes in $100 million. And then you have Daimler, who made a truck, spec'd it correctly, nothing illegal about how they spec'd it, all safe and whatever. And they have a rollover, and the driver, the trucker, recovers $160 million after being rendered a quadriplegic. These verdicts are not going away. They are not slowing down. This is not a question of the government can come in and save you. This is a question of really big, big issues. My hope today was to help you understand those three cases, at least as best I could under the circumstances. Have you understand at least why we didn't learn about the seatbelts or why we didn't learn about the blood alcohol content from the juror's perspective in that Wabash case. And then ultimately we look ahead, because cases are won and lost at the jury room, but they are not finished. They continue on. We are now just about at the end of the Werner case. It will be at the Texas Supreme Court in the beginning of December. A couple months will pass, and then a rule will come out. And that will be the final rule. That'll be the final. That'll be the end of it. It will not go to the U.S. Supreme Court. That can't go to the Supreme Court. It is a Texas issue. And maybe Texas legislature can make modifications. But if I'm an insurer, I am very, very curious about the outcome of that litigation. If I'm a trucking company, I'm very curious about that litigation. If I'm a broker who might be susceptible to broker liability, I might be concerned. Heck, if I'm a shipper and I have my own internal brokerage house, I am paralyzed because, yes, I thought I was going to save money, but nobody told me that I might have $100 million verdict that might be up the road ahead. So that's it. That's a breakdown of the nuclear verdicts. I will hopefully see you at the Inland Distribution Conference. I'll hopefully see you at DATCON. Hopefully I'll see you at Broker Carrier or F3. I hope I do. If you do see me, I'd love to talk with you and scream about the world and maintenance of our industry. Before I start wrapping up, I'm going to start looking at these comments, and I'm going to post a couple, and we'll answer them if they're questions that I didn't get to. Let me just give me a second. You know what we'll do as I do that, I'll play some music. This is the normal music. Let's go through the questions. This was fun. I like this. Thank you for joining me today. Sage Outcast. I like Sage. Good to see you, buddy. I hope you're doing well. LinkedIn user. Yes, I hope I was helpful. I hope this was useful for you today. Let's see, from Graham Gonzalez. Oh, I love Graham from Reliance Partners. I am a huge fan of Reliance Partners. If you are a broker or motor carrier and you are looking for a great agency to help you understand what it's like to operate a commercial fleet at scale, these guys are fantastic. Here's the question I hear, or the comment at least. I hear it argued that swerving to avoid this oncoming passenger vehicle or slamming on the brakes could have been a much worse fatality result. 70% fault assigned to Werner is likely tough for anyone in transportation to understand. Yeah, I mean, the reality for this event, there was really no time. I mean, there was no time. You are talking about a vehicle probably traveling at 50 miles an hour or faster, maybe even 60, crossing the center line as you're going like 50, 60 miles an hour. That is a very fast. It's a split second. It's like 3-4 seconds until it's over. So the ability for a professional driver to react in those contexts, very, very hard. The driver really does want to keep you home in the same condition you leave, but this is a different world. We live in the most distracted driver society that's ever existed. People all have phones all the time. Another comment by Gran. Is this the new standard litigation targeting all the major manufacturers for any safety parameter that is no longer relevant? The price of trucks could increase astronomically, would wipe out thousands of small trucking companies. Absolutely. I mean, hold on. That's a great point. Yes, that's the idea. Look, let me pretend to be a plaintiff attorney for you for a moment, okay? Let me pretend to be a plaintiff attorney. I just had to watch my client bury their 11-year-old son. I can't help you with that. I can't do anything about the fact that you had to bury your son. All I can do is file a lawsuit and figure out who's responsible, who's anywhere near this chain of custody, this value, these stakeholders. Who can I target? Who can I examine? Who can I go after? And if I'm going to do that, I'm going to look at every single entity involved. I'm going to look at the motor carrier. I'm going to look at the maintenance providers. I'm going to look at the shipper. I'm going to look at the broker. I'm going to figure out exactly who might be responsible. Because remember what I said just a few minutes ago. The minimum insurance that a motor carrier carries in this country for doing interstate commerce is $750,000. They absolutely know that that risk is not insured enough. That is not enough insurance. But what am I going to do? Because the minute I sue that trucking company, their insurance provider tenders the policy. They say, hey, here's this pile of money. That's our legal responsible limit. Go pound sand for the remainder. Or sue the company, put them in bankruptcy. We're done. People go bankrupt and make a new trucking company just a couple of months later. So what are you going to do as a plaintiff attorney? You're going to understand how this system works, who's around, who's responsible, who's vetting, and then you're going to target each and every one of them. I would even submit, and I don't want to put this on record, but I'll say this, I think if you don't do that as a plaintiff attorney, you're probably committing malpractice because there is money to be found. So the idea that we have had in this industry that we can limit our liability simply by having different organizational structures is not going to be the case for very long. It's not the case now. It's not the case now. So we really, as an industry, got to come to terms with one, we are underinsured. Two, we don't maintain things properly. And three, lawyers are creative. So to Graham's question, yes, this is the path. This is how it will go. It's not just going to be sue the trucking company, get a settlement and move on. It'll be sue everybody. Let them fight against me individually or in the litigation, and we'll see who's left standing. Because I cannot bring back the dead, but I can absolutely bring back some money. And that's what drives so much of this litigation. Back to the comments. So hopefully that was a good version of that. Act of God attempted with the weather. That's a good question. So the question, as I kind of synthesize this, is the weather is bad. The driver can't control the weather. Isn't that an act of God that would eliminate the liability? Probably not. Act of God stuff is different. The way to look at act of God typically is like a lightning bolt strikes you and you're dead. Like there's something that is absolutely impossible for you to predict. Bad weather, we know what bad weather looks like. We know it coming in advance. We have a pretty good understanding of what we can do, what actions we should take. Should we go slower? Should we just park the vehicles? So act of God certainly is a way to try to approach this. And I guarantee you in the affirmative defenses, they throw that out there. Say, it's an act of God. We can't control it. But it's more like there's a massive earthquake. The truck then fell through a gap and smashed somebody. That's more of an act of God. They're not as strong as a defense as we might think, but that is the way to look at it. Mike Wolf has a question. Were all three of these mentioned nuclear cases, Wabash, Werner, and Daimler, strict liability? No. Wabash and Daimler were strict liability. They were the ones that said, look, it was made defective. It was made defective for the anticipated use. Werner is just run-of-the-mill negligence. Duty, breach, causation, damages. That is what Werner was. Wabash and Daimler, this is actually a point, Mike, I'll kind of emphasize this. This is where I'd say the future is going, which is to say, if we can prove that the manufacturers were liable, they were strictly liable for making it dangerous, if the motor carrier continues the same thing, now knowing that it's defective, maybe they're liable for that same thing now too. So the negligence aspect for other motor carriers, I think, increases as manufacturers are targeted with strict liability. I would be very surprised if there's like national recalls on trailers to make the rear impact guard stronger. But this actually segues into a really good piece, and again, we're getting close on time, but I got no time constraint. This is my show. You stick around if you want to, or get out. I don't care. There's a thing called side impact guards. This is a highly, 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 let me emphasize that, highly controversial thing going on right now. So you look at a trailer, and I love trailers. They have these things on the sides. We call them skirts. People call them wings. I call them skirts. And those skirts are designed to prevent some air drag, make them more aerodynamic, less fuel consumption. That's the general idea. Those are not designed to prevent underride. And we absolutely see from time to time side underrides. The most typical case you see with a side underride is when a truck is turning and that trailer is kind of in the middle of the road, and a person who's not paying attention because no one pays attention smashes into that, and they have a side impact underride. Again, the disinfected term of saying a decapitation. And when that takes place, people have been asking, should we mandate at the federal level side impact guards? And the estimates vary quite a bit, but I've heard like $2,000 per trailer to do a retrofit of a side impact guard that would prevent underride at whatever speed, probably 35, but who knows? That would add a lot of weight, a lot of expense, obviously. But people have been kind of saying, like, well, is there a theory that the plaintiffs will go after with those? So if we were able in this Wabash case to make up a new standard, 55 miles an hour, let's say, for the rear impact guard, is there the same pathway to target a motor carrier or a manufacturer for not including a side impact guard, even if it's not legally required? That is a very, very complicated, very interesting thing. And I would be surprised if we don't see something like that continue on. I'll note on the rear impact guard side and the underrides we've been talking about, the data isn't great, but it's less than 15,000 people total that have died in a rear end underride. So this situation, this set of facts, is rare. It is not a common thing. So it's, again, a rare thing to happen. And we're now looking at, manufacturers facing just absolutely bonkers amounts of liability. I think that's most of the ones that we had to see. Let me see. This is one from Robert. This was earlier in the program. I'll touch on it one more time. His quote here is, "I just do not get how the driver and passenger not wearing seatbelts was not relevant. If they did not go under, they would have been ejected out of the car into the trailer and been killed that way. Just doesn't make sense." No, I agree. Let me kind of redo a little bit of that kind of piece of it. In negligence, we care deeply about the actions of others and how that contributorily impacted the damages. So there's causation, and causation can also have the other yahoos who didn't do the right thing. Product liability doesn't require that. We don't need to know anything about the person who got injured other than the anticipated use of the product, the item. And so we didn't need to know that they were drunk. We didn't need to know that there was seatbelts that weren't being used, because that was not the thing we were talking about. The product was the rear impact guard preventing an underride at a speed. Now, the legal thing in terms of the federal system was 30 miles an hour when the trailer was manufactured, and then 35 miles an hour much later on by the act of government that did not require retrofits. So this new standard of over 40 miles an hour, over 50 miles an hour, was never a standard we had ever anticipated. And Wabash was very clear about this. I mean, they have a great statement that they put out and said, look, there's no rear impact guard that exists today that would have prevented this thing from being a fatality. There's nothing. This is what was going to happen regardless based on what these people did. But that's not the standard. That's not what matters. So it's very important to kind of separate how these legal theories work, because lawyers, we do a thing called pleading in the alternative. We set up different claims based on different sets of facts, or the same set of facts, but different claims based on those facts that require different levels of participation from the injured person. Strict liability, I don't need your participation. I don't need to know anything about what you were doing other than the fact that the thing that the the item was designed to prevent failed. That's all that matters. Then the damages come naturally from that. I think that's everything. We'll be doing more of these, I think, over time. Look, I am so appreciative of the folks who have tuned in today to kind of get a better understanding of this ridiculous world we find ourselves in. This litigation is not going to slow down. It'll only accelerate, and maybe there will be tort reform that can help kind of adjust this liability we see. But if you're an insurance company and you're looking at this, you are very, very concerned, because this type of liability is something that's completely outside of your insured's ability to stop. I mean, you can't prevent somebody from losing control and smashing into you. You can't prevent somebody from going super duper fast above the thing is rated for and collide with you. So it's a big risk that everyone's got to deal with. And I hope that this has been helpful for you. Please don't hate the lawyers. I mean, we're not all bad. I mean, most of us are somewhat human. I include myself in that group, but the hourglass is running low. I gotta say thank you to my friends at DAT. I can't wait for you to gear up for DATCon, folks. I will be there. I hope to see you there too. And any other place you find me or on the interwebs, please reach out. I love talking to people. I love helping take complicated legal topics, try to make them make sense, and then ultimately you walk away knowing just a little bit more about how this thing is likely to go. Again, the last bit I'll say, the Wabash thing will be reduced and maybe dismissed on appeal, maybe. Werner, we have no idea what's going to happen. Texas Supreme Court, December 3rd. That's a big date. We have to follow that. It'll take a few months after the oral arguments, but for the legal people watching and the folks who are interested in this, the way they question people about this law and this case will kind of give us a good indication of how those judges will rule. But when the judges in Texas eventually make their ruling, that's it. That's the end of it. There's nothing else you can do. And then this Daimler case, brand new case, we'll see what that results in. It's a little bit different. Again, it's the trucker himself who sued Daimler for not having the protective system that would prevent the neck being broken on the case of a rollover. We live in the most distracted society in human history. There is very little you can do to prevent people from not being paying attention. And so keep your eyes vigilant. If you're a four-wheeler out there, if you're just a normal person driving, give truckers plenty of space. They do something that is something very, very difficult. Not many people can do. We all are here so that we can hopefully get everyone home in the same condition that they left. And safely delivering freight on time and undamaged is difficult even under the best circumstances. It's only getting harder. And so I hope that this was helpful. And thank you all for your wonderful comments and feedback. Have yourself a great day. And yeah, that's it. Let me play the music. We'll do that. I do that next thing. Yeah, that's it. Hey, we did it. I'm thinking next week I'll do one of these things, but I'm gonna have a code that I can message people. So random people, if you want to just randomly come and ask me questions, that would be kind of interesting. Be fun, I think. If you're interested in that, we'll talk about that later. Hey, thank you. Have a great day. The law, the supply chain, they intersect. They always have. They always will. And hopefully we'll all be there watching, waiting, and learning. Have a great day. End the stream. Press the